Thank you, sir.
SJC-11291, Commonwealth v. Darrell C. Webb.
All right, let's proceed.
Good morning, Mr. Chief Justice. Good morning, Your Honors. David Keeley for the defendant, Darrell Webb. Your Honors, I'd like to reserve 2 minutes of my time for rebuttal. And before I begin my argument, I'd like to alert the court to an error that I made in Mr. Webb's supplemental record appendix at pages 1 to 10. I included a copy of exhibit number 44, a unredacted copy of that plea agreement. However, I made an error there, and the correct copy, the copy that actually went to the jury, is in the Commonwealth's brief.
Do you agree, so you agree it was redacted?
Oh, yes,
Yeah.
yeah, no question about it, Your Honor. And that leads me to direct the court's attention to page 17 of Mr. Webb's brief. The first full paragraph, I request that first full sentence in the first full paragraph be stricken, because the argument contained therein is not a viable argument. I'm not making it. I withdraw that argument. So having said that, Your Honors, I'd like to, I just submit here in this case that there was some missteps taken in the handling of the plea agreement and the immunity agreements that the two witnesses had. I have four essential points I'd like to make. The first point is on a direct examination, the prosecutor elicited from witness Galloway and Taylor their truth-telling obligations. And the argument is simply that that should have waited until redirect examination.
Is that hard and fast law?
You know, Judge, I don't think it is. Chiampa, the seminal case, Chiampa says, well, you got to wait till redirect. But even in Chiampa, there's some, for want of a better term, there's wiggle room. Some of the later cases, Rivera, Morello, which is cited in the government's brief.
And Rolón?
Yes, and
Rolón. I mean,
Rolón.
there's a suggestion that if the issue comes up early in the case, that it can come in direct examination.
Right, but I just returned, even in, but even in those cases, the Rivera from 99, you know, the first paragraph says that they should wait till redirect. And I guess there's an exception if the defense counsel gives a strong signal in the opening statement that there's
Isn't that
going
what
to
the
be.
Commonwealth says happened here?
The Commonwealth says that's what's happening here. I just say that the defense counsel in the opening makes it's 2 sentences. It's a very brief, generalized remark, basically that telling the jury that, you know, there's some agreements here, there's some immunized testimony. Pay attention to it. And he uses a colloquial term, which is, you know, a rat. That's colorful, but I mean that's a squealer or a tattletale. So I think those are really actually generalized remarks requiring the Commonwealth to wait until redirect to make to draw out the truth-telling obligation. So, you know, really, that's I think that's a fair argument. The second point I'd like to make is the judge should have redacted from the federal plea agreements just the signatures of the federal prosecutor and the federal plea counsel. Redacting is important because of the danger that the counsels believed that the clients would be telling the truth.
Well,
And
I mean, on that point, though, don't you think the instruction that the judge was supposed to and did give about, you know, the Commonwealth or nobody knows whether they're telling the truth, that's really for you to decide?
Well, that's true, and that instruction was given. I mean, we do have a quarrel with portion of the instruction. But nevertheless, I'm not sure a jury's going to make the connection when they're looking at these plea agreements, particularly when they're coming from a different jurisdiction, Judge, Your Honor. I suggested there might be, I don't know that the connection's crystal clear, and we know from other cases, other contexts, other issues, that juries sometimes have trouble applying a judge's instructions. So,
No, say it's not so.
well, I like to believe that's the case, Your Honor.
Yeah,
And, you know,
I don't quite get I mean, I understand the concern if the prosecutor in the case on trial is the person who signed the agreement, because then
Right.
he or she is appearing before the jury, but what difference does it make if somebody who's not at trial has signed the agreement, who the jury's not going to know who the person is?
Well, because they see it's the imprimatur of a counsel, and in this case, it was counsel for 3 very important Commonwealth witnesses. I mean, I don't really see, to be honest with you, I don't really see in the minds of an average juror who's unschooled in the nuances of the law that, okay, if it's a state court case, you're going to have this, you don't want the state court prosecutor's signature on the plea agreement and defense counsel. So it's a different jurisdiction, but I think that's a distinction. The jury, one thing, the jury's not even told about that. So are they going to make that distinction? I just think it's the same thing. There's no distinction here, really, Judge, in my mind.
But isn't it better to have somebody else's signature than this prosecutor's signature on there? I mean, the jury's going to know it's an agreement, and that it had to have been made between a prosecutor and a defense lawyer. They're not totally, babes in the woods here. But isn't it better to have somebody else's signature on it other than this prosecutor's?
Well, to be honest, I mean, it's better to not to have those signatures there. That's the point. The argument I'm making today is that whether it's the state prosecutor or a federal prosecutor in a case that's not even in, it's another jurisdiction, I think the jury looks at that and just say, well, okay, Galloway and the 2 others, Texera and the third, whose name escapes me at the moment, they've made an agreement with the prosecutor. It was in federal court, but it's in the state court case. I don't know the jury's going to make that distinction. So
if they had done it right, it would have said, a signature would have been blocked out. It would have just said AUSA, Assistant U.S. Attorney.
just take the names out. Yeah, I mean.
But it would still say Assistant U.S. Attorney.
Well, I don't think that in typing, in print, well, I possibly, yes, I suppose so.
Or would you have us redact that as well?
I think it should all be out. I mean, that might be an extreme, because then the jury's looking at it and saying, well, what is this document? No one signed the darn
They
thing.
put the S sign.
But that's what the case law talks about, the points that need to be, paid attention to when you're, and in this case was, as the court well knows, it was these witnesses, this case was about the testimony of these witnesses. Aside from the ballistics, the whole case was the government's 5 witnesses, the plea agreement witnesses and the 2 immunized witnesses. Which actually leads me to my third point, which is, again, the judge's instruction in terms of the plea agreements was spot on. But our argument is the judge needed to go that very explicit and specifically give that instruction when the judge was instructing on the immunized witnesses' testimony. And I'd just like to point out that this court, I believe in Morello decision, which is in the Commonwealth's brief, there's a model instruction in the appendix which has, with regard to immunized testimony, the same explicit directive, take great care with this, as appears for plea agreements. And so what I'd ask the court to do today is take the case of Commonwealth versus Miranda as the example. In Miranda, this court required a very explicit instruction in a case involving a compensated witness. A heightened scrutiny is to be brought to the testimony of that witness. I just think of a phrase I heard years ago at oral argument, the jury needed to have it rubbed into its ears over and over and over again, because this case was all about the plea agreements and the immunized testimony. Next point I'd like to make is that the jury should have been told that the witness's federal guilty plea agreements was not proof against the defendant in this case. And I recognize, Your Honor, that that's somewhat attenuated because they're not accomplices, but nevertheless, I think a jury might be susceptible to drawing a conclusion that because they pled guilty, that because these 3 guys pled guilty, certainly Galloway, I think, could have been charged as an accessory after the fact.
But it was clear that the crimes for which they were pleading they were not connected to this one, right?
No, they weren't. No, they're federal.
I mean, I know
right.
that they weren't in fact, but wasn't that also clear to the jury? or not?
Well, I think that might be some room for doubt there. If they read it, they're going to see that. They're going to see that, but the point I'm trying to make, Your Honor, is that Galloway and Burton and Taylor could have been charged with first-degree murder in this case. And Galloway arguably as an accessory after the fact, maybe even before. I haven't really, thought that through because I don't think it's necessary to, but the point is that they were involved in this case, so there's some danger, I think, that they're pleading in another jurisdiction, even though it's of crimes that aren't involved in this state case, that there might be some confusion on the part of the jury.
But
with regard to that.
wouldn't the instruction you are asking for produce more confusion? Because it would suggest that they should not consider the guilty plea that has nothing to do with this case to bear on anything to do with the case on trial? I mean, if anything, it suggests exactly the inference that you're saying you're warning against.
I think the judge could fashion at least some cautionary remarks to the jury along those lines. It might even, it would be difficult,
These
perhaps.
witnesses pled guilty to crimes that had nothing to do with the crimes on trial, but you should not take the fact that they pled guilty to reflect anything as to whether or not they, I'm trying to think what the instruction would be.
Something like that would probably do the job, because again, as I said a moment ago, these three witnesses, Taylor, and I'll say it again, Taylor and Burton avoided first-degree murder charges. And Galloway, accessory after the fact, maybe even before because of the weapon, there has some role. So I think the suggestion that Your Honor just made might well do the job. My last point I'd like to make is our argument is that there was some vouching in this case. The ADA in the closing argument said that the witness has had a motive and a desire to tell the truth, no motive to lie, and the immunized witnesses could be prosecuted for perjury. And by the way, Your Honor, there is that last remark was objected to, and properly so, because there's no evidence in the case that they're going to be prosecuted for perjury if they lie. So the argument is a reasonable jury could have understood those remarks as the government's assurance that the witnesses were truthful by virtue of the plea agreement. And also, the plea agreements suggest that the plea agreements for the three federal witnesses suggest that the U.S. attorney had the power to prosecute them for perjury if he had the leverage to do those things. So that would just lead this jury to believe that these witnesses were being truthful because they were either immunized or they were under plea agreements. And I think that constitutes vouching.
But it's true. I mean, the federal prosecutor could prosecute them for perjury. That's the only thing they could be prosecuted for with regard to what they were testifying about.
But, and the danger is that it's the federal prosecutor that decides, whether or not they've perjured in any statement, in any jurisdiction, in any court. So that's that means that the U.S. attorney has leverage over them.
Right, but that cuts both ways, though. I mean, so
Yeah.
I've seen defense counsel use that to indicate that they're not going to prosecute you for perjury if you testify the way the Commonwealth wants. But I don't understand why it's not appropriate for a prosecutor to tell the jury he has immunity, but not with respect to perjury. If he commits perjury, he can still be charged with a crime.
Well, I think the argument is that the perjury admonition in the plea agreement should have been redacted, at least. So that's really.
Wouldn't that suggest that the immunity is greater than it is?
Well, I'm not certain of that, Your Honor, but the fact is that the cases talk about that there's a danger there, that because the U.S. attorney or in state court, because there's that leverage, is that it's a hammer that the prosecutor's using to get the truth from these, to get the prosecution's version of the truth from these witnesses. And Your Honor, I mean, everyone knows that the government has talked, these are the government witnesses, they've talked to them beforehand, they've entered these agreements with them. There's for want of a better term, there's a script, or they know everybody knows what's expected. And that's the danger inherent in any plea agreement. There's expected testimony. If you don't give us what's expected, we're going to charge you with perjury. So, and that's the danger.
Right, but that's what defense counsel should bring out in cross-examination, I would think. And that's
what's-
the other side of this perjury piece, which is, as I mentioned before,
Right.
the Commonwealth is not likely, or the feds are not likely to prosecute you for perjury if you testify as they want you to, and therefore you must testify to what they want you to say because you're concerned about perjury. But that seems to be a defense argument, not something that isn't appropriate for the jury to consider. In fact, a defense counsel should want the jury to consider that.
Well, to defense counsel's credit, the cross-examination was very thorough, so, I think the point was made, so. If there are no further questions, I'll reserve my time.
Thank you, counsel.
Good morning, Your Honors. Audrey Anderson for the Commonwealth. If it pleases the court. On direct examination and without objection, the Commonwealth asked witnesses if they were testifying pursuant to federal plea agreements or to a grant of immunity, and their obligations to testify truthfully. There is no absolute prohibition on presenting the terms of the agreement on direct evidence. It is up to the judge. The trial judge has discretion if this is to be allowed.
But it doesn't Champa say that that you're supposed to do it on redirect?
It's better to do it, it does say that you're better to do it on redirect, but there are a number of cases in my brief that also say, but if the defense counsel has made it very well known that he's going to challenge the defendant's credibility on cross-examination, then this may be done on direct. And the defense counsel did. He made several statements. They're only doing this because they're going to get something from this. They're being rats. He's saying to the jury, be careful what they say. Be careful how you listen to them, which is fine. You should be careful how you listen to them. But this was brought out. And there was no surprise here that that he was going to bring out this testimony on cross-examination. So it was proper for the prosecutor to bring it out, and it was just a fleeting statement, and there was no objection from trial counsel. I'd like to go into the redacted signatures. As counsel stated, the signatures were redacted that went to the jury on the federal agreements. Those signatures were redacted. And on the state immunity agreements, those were never entered into evidence. As far as the federal agreements and the signatures of the federal prosecutors and the federal attorneys, the defense counsel did not ask for them to be redacted. This was discussed. The redactions were discussed. He didn't ask for them to be redacted, and a court is not required to do it sua sponte. The judge's instructions to the jury. The judge was very, very thorough in his instructions. He advised the jury to consider any future advantage that may come for the agreements, to consider the agreements. He told them that the government did not know if a witness was telling the truth, that it was up to them to decide who was telling the truth. He adequately directed the jury's attention to the potential influence of the agreements on the witness's credibility and the fact that the government did not know or was not warranting that the witnesses were telling the truth. The federal prosecutors' signatures that were there, the federal prosecutors weren't there. There's no indication that there was anything going on with them. And I think the vouching I'd like to address, unless there's any other questions. Anything else? The vouching that the, supposedly that the prosecutor did. The prosecutor basically stated that it was basically a motive argument, that
I'm sorry, I just didn't understand that something, what was the word you used?
A
Mo-
motive,
A
the
motive,
motive of the witnesses to testify the way they did. She basically said they testified about what he told them, about what they saw. I suggest to you, they wanted to tell the truth. According to Mr. Burton, and he said, I wanted to tell the truth. She didn't say he's telling the truth. He said that he wanted to tell the truth. She also says that, I suggest to you, the incentive is to tell the truth, to cooperate to the agreements, and that the people that got immunity, the two people that got immunity, were not immune from perjury charges. And I believe this is what counsel was speaking about, but when he was saying about, that it wasn't in the record, that they could have been prosecuted for perjury. And it is in the record that they could have been prosecuted for perjury. Volume 3, page 114 to 115. And volume 4, page 103, that was in the state immunity cases. And that's what counsel referred to in his brief. Are there any questions, Your Honors?
No, counsel.
Thank you.
Thank you.
Thank you.
Respectfully request that the convictions be affirmed.
No rebuttal, Your Honor. Rest on the brief.
Thank you, counsel.
All right. Hear ye, hear ye, hear ye. All persons having anything further to do